Good afternoon. I'm very pleased to be here to introduce our next speaker in the Empire Lecture Series, Steve Ansolabehere. I'm Chris Mann from Louisiana State University. I've known Steve first through his work and then as a mentor and an inspiration working on election administration, and I am looking forward to this talk. He's always been a very generous with his advice and his assistance, and very wise about the way our elections are run and what we can do to improve them. He is the author of 5 books: The Media Game, Going Negative, American Government, The End of Inequality, and most recently, Cheap and Clean, How Americans Think About Energy in the Age of Global Warming. Those books tell you the breadth of his work in addition to what he's going to talk about today. He's been a Carnegie Scholar, a Hoover National Fellow, a Truman Scholar, and was inducted into the American Academy of Arts and Sciences. In addition to all of his own work, he's the principal investigator of the Cooperative Congressional Election Study, a true public good, furthering the research of people like myself and many, many others at 60 collaborating institutions. His topic today is Democracy's Boundaries, Political Science, and Voting Rights. Please join me in welcoming Steve Ansolabehere.
Thank you, Chris, and thank you, Gary Jacobson, for inviting me to have a chance to talk about anything I wanted to talk about, which is a very dangerous invitation. But I figured what I would most like to talk about is how political scientists are involved in a very real, practical, meaningful way in shaping the definition of American democracy. And I was going to take one little piece of the many ways in which we as a discipline form the evolution of our democracy, and that's just the dispute over district boundaries since 2011. Every once in a while in our lives, we step into a river that's going way too fast, and that's what happened to me in the summer of 2011. It was July 25th. I will never forget this date. I got a call from a man who I'd never met before. He was a lawyer in Texas. His name was Renee Hicks. And Renee, with a sweet Texas accent, just you can't say no to somebody with an accent like that, calls me up and says, you know, I'd like you to think about whether you could help us in this voting rights litigation in Texas involving the Texas congressional district map. And I thought about it for a couple of days, and I had stayed out of the conflicts in 1991 because I was too young. I'd stayed out of the conflicts in 2001 because I was running the Voting Technology Project, and I thought it was best if the leader of that project was outside of the political fray. And this seemed like the moment, if I was ever going to really dig into the voting rights litigation that was gripping the country, this was my opportunity. So after a couple of days thinking about it, I told Renee, yes, I would do this. And then I dug a little deeper in the conversation about what would be required, and it all seemed very reasonable, pretty straightforward application of what we as political scientists do. In fact, a lot easier than a lot of the things that we have to do to get a journal publication. But on a different time scale. I asked Renee when the first report would be due, and he said August 8th. And I went from knowing nothing about what had happened in Texas to being pretty deeply immersed in the span of 2 weeks. In college, I pulled one all-nighter. In that 2-week span, I pulled 2 all-nighters, and it was not going to be the last of those over the course of the next 4 years, where I've been involved in at least a dozen different cases involving redistricting, voter ID, and even one man, one vote. Those cases involved redistricting in Texas, a special district in San Antonio, Texas voter ID case, Nevada redistricting case, Florida redistricting cases, Virginia, North Carolina, and I've also been asked to advise on districting conflicts in other states in which I fortunately did not have to go testify in front of a judge. What did this work involve, and what do people like me and many others, many of our colleagues are doing this kind of work regularly? What did it involve for us on a very practical level? The first report I wrote was 65 pages long. So between July 25th, I had to assemble the data, analyze the data, come up with my understanding as best as I could of what actually happened in Texas, who was affected, and how were they affected, and then write a report. that would hold up in a court of law. There were other reports written in response to my report. I had to write a report rebutting those reports. Following those rebuttal submissions, and that report was around 35 pages long, I had to be deposed. That was 2 days in Texas in the middle of September, and then we had a trial. And I was asked to go to federal district court in San Antonio and be questioned about my expertise in this matter and what I'd come to advise the court on. What do we advise courts on? Well, we advise courts on very specific questions pertaining to voting rights. One, what is the effect of the law that the state or administrative agency has passed? Who is harmed? Very simple question, not easy to answer. But we use a lot of our quantitative tools to try to assess the extent of harm. In particular, are there disproportionate harms that minorities suffer as a result of a particular act? For example, does the voter ID law in Texas disproportionately affect blacks and Hispanics compared to whites? Second, what kind of intentionality evidence can we bring to bear? Some of the effect evidence that we bring to bear actually does bear on questions of intentionality, but political scientists who do qualitative research on legislative behavior have a lot to add to the court litigation on questions of intentionality. What was said in the committees? What was said off the record? What information can be found out? This actually, I think, is an area of social science where we are weaker than we ought to be. I think the quantitative research that we contribute to these court deliberations is much better than the qualitative work. Third, what's the remedy? Can we point to specific things that can be done to fix the problems? This, too, is often, I think, a failing of ours in legal questions. So what I'd like to do for the rest of this talk is talk about what's happening with the Voting Rights Act and law in the United States, what social scientists are contributing to the development of that law, and then 3 cases, the Edwards Aquifer Authority case, the Texas redistricting cases, and the Florida districting cases. I could probably talk to you all day about one of these cases, so I'll have to be brief. So what's happening in election law and voting rights law as I see it? First, there are questions of general voting rights, equal protection. Believe it or not, those questions are still floating around, even though most of the big questions were answered in the 1960s. In particular, there's an interesting exception that the Supreme Court carved out, and that exception is for special districts. That is, a water reclamation district. Its only authority is to move water around or to build a dam. It doesn't have the power to tax or to regulate behavior. Those districts are accepted from the one person, one vote requirement. And as our colleague Chris Berry at the University of Chicago has demonstrated or documented, that is the fastest growing part of government in the United States. So the fastest growing part of government in the United States is exempt from equal protection. Second, the protection of minority voting rights in particular. The Voting Rights Act, which was passed in 1965, has been amended, extended, and renewed multiple times to expand the protection of voting rights in the United States. There are 2 key parts of the Voting Rights Act, and I think as you read about this in the New York Times, as these cases are going to come up from, or the Washington Post or whatever your newspaper is, as these cases evolve from the court over the next couple of years, and they will come out over the next couple of years. The cases are going to fall under 2 categories, Section 2 and Section 5 of the Voting Rights Act. The Voting Rights Act is very short, so you can go and read it, and it makes total sense. It's not an overly complicated law. It's certainly not the Affordable Care Act. Section 2 basically is the enabling legislation of the 13th and 15th Amendments. It basically says you cannot intentionally discriminate against racial minorities in the procedures governing elections. Section 5 is a particular criterion. Any state, county, or other jurisdiction that falls under special protection must go to the Department of Justice before it implements a law and get approval. There's a subtle difference between these legally. In the first case, someone has to sue the state. The state is the defendant. In the second case, the state has to prove to the Department of Justice that they've done no wrong. The state is, in some sense, the plaintiff, even though they passed the law. Section 5 is required, preclearance is required of states, or was required of states under what was called Section 4, a list of states and counties that from 1965 on were required to go to the Department of Justice for preclearance. These included Arizona, Alaska, Alabama, Georgia, Mississippi, Louisiana, Texas, parts of Virginia, parts of North Carolina, a few counties in Florida, South Carolina, a few counties in Vermont, New Hampshire, a couple counties in California, and 3 of the 5 boroughs of New York City. Earlier last year in Shelby County case, the Supreme Court voided Section 4. So nobody is required now to go get pre-approval. However, there is little criterion in Section 3 of the Voting Rights Act that says that any jurisdiction that is found to have intentionally discriminated, which you can show under Section 2, can be required by the Attorney General of the United States to go under Section 5. And I think one of the things that's going to happen with the Voting Rights Act in the future is that Section 2 and Section 5 are going to start to work in tandem. If a state loses a Section 2 intentionality discrimination suit, the Attorney General will sue that state to bring it under Section 5. This might change the application of the Voting Rights Act completely. The city of Boston, which lost a Section 2 lawsuit for discrimination against Chinese language nationals, might now be brought under Section 5. That would be very interesting to have Boston be the only place to have be required to have preclearance. The voiding of Section 4, though, is going to shift all the action to Section 2. We're going to see a lot more Section 2 lawsuits, intentional discrimination lawsuits over the coming years. Third big change in election law and voting rights law is the rise of state laws. The states are starting to assert voting rights laws in a way that they never did before. We saw very important reforms in many states, but I'm going to talk about Florida because Florida had the most extensive legal reform in terms of laying out new criteria, new ideas about what counts as equal representation, equal protection. In particular, the state of Florida is the first jurisdiction to define in its laws that there can be no party bias. Now, what that exactly means, no one is quite sure yet, but it's going to become the opening for a very large expansion in the concepts of equal protection as it is applied to political parties, not just to racial groups and to general population. Finally, I think there are some very big questions lurking, and we'll come back to those, about what is a minority district? When are minorities protected? Under what circumstances? And I think these are completely unanswered questions. Let me turn then to what the social scientists are contributing, because there's been an explosion in the social science contribution to litigation over voting rights and other ways of protecting voting rights. The first of these revolutions is the GIS revolution. This is coming out of the geography field, but it's really opened things up, and I think if you go to any of the major universities now, you can get GIS training as a graduate student. That didn't exist. When I went to graduate school, I couldn't be trained in how to draw maps in a political science department. Now I can take a GIS class and in a couple of weeks learn how to draw my own maps. What's more, there's now free software online. There's a software developer from Microsoft named Dave Bradley who has Dave's Redistricting app. You can go online and find it and pull it up, and you can sit there and draw your own maps. Anybody in the United States can draw any map they want for their districts. This has really changed the districting politics because it used to be the case that districting politics in the United States were an insider's game, and really only the majority party, only the governing party had the resources to draw districts. Only they had the training, the staff, and had the funds to pay for expensive software. Now anybody can train instantly. It's very easy to use. It's easier than most video games, at least for me. Second change is the analytics revolution. Now, a lot of us are used to doing regressions and so forth, so for us, like, oh, the analytics revolution, whatever, we know all this. But everybody's becoming a lot more sophisticated. They're catching up to us. And also, it's more widely held what kind of tools we can muster. I think one of the big tools that's going to start to take off, and we saw it a little bit in the Florida case, is simulation of districts, random generation of districts. What's fair? Well, randomness might be taken as what's fair. And our colleagues, John Roden at Stanford and Joey Chen at Michigan, have developed a very compelling simulation set of routines that were central to the Democratic Party's efforts to overturn the Florida redistricting map. Third big change is data availability. It used to be impossible to get precinct-level data, the kind of data that the state legislature would use to draw maps. Now it's up there publicly online. In fact, my colleague Nate Persley at Stanford Law School encouraged me, I think I look back on this and say, why did I do that? Encouraged me to develop the Harvard Election Data Archive, which is an archive of precinct-level election returns merged in with census data for every precinct in the United States, or at least every one we could get our hands on. Between the GIS tools, the analytical tools, and the data availability, anybody can draw a map, analyze, upload the data, whatever data they want to evaluate the map on, and analyze that map and present it as a legally defensible map. And in some states like Virginia and Florida, that totally changed the political discussion and the legal discussion. Let me talk about 3 cases then. The first case is the City of San Antonio versus the Edwards Aquifer Authority. City of San Antonio is 75% of the population of an area of a board that governs the use of water in, not the use of water, but the regulation of water in the City of San Antonio, counties a little northwest of there, counties to the east of there as well. West of there and northeast of there. They have 40% of the seats. So the rural counties have 60% of the seats, and the City of San Antonio has 75% of the population. City of San Antonio sued. For me, it was a very easy case, just involved taking the maps, GIS, uploading the population data from the census, counting up how many people there were. That was one piece of it. The other piece of it was just going through and understanding what the regulatory authority of the agency was. And then the only question became, is this the kind of agency that ought to be regulated under equal protection? This is an outstanding case. It has not been decided. We don't know what the courts will ultimately be deciding, but as I mentioned earlier, it could be a potentially very important case because it could be an opening to further exceptions from equal protection and one man, one vote. Second case, Texas redistricting. The Texas redistricting case that I got involved with in July 2011 became 3 cases. It expanded and contracted and expanded again with the changes in the Voting Rights Act under Shelby County. It is an unbelievably complicated case, but basically what it involves is the 2 components of the Voting Rights Act and the relationship between them. I said before that Section 2 is prevention against intentional discrimination. In 1986, in the case of Thornburg versus Jingles, the Supreme Court set down what evidence would be required to show intentional discrimination. What quantitative evidence could social scientists bring to bear? Bernie Grofman's work in that case defined everything that happened afterward. It defined how social scientists were to use evidence to show intentional discrimination. Section 5, I said, involves preclearance, and it's mainly concerned with reductions. You can't take away from minorities voting rights that they've already gained. Okay? So then there became this fight in Texas over what counts as a minority district. There's a real tension between these 2 parts of the Voting Rights Act. In fact, our colleague at NYU Law School, Rick Pildes, wrote an article famously entitled, "Is the Voting Rights Act Now at War with Itself?" because the things that might require reductions, might appear to be reductions, might be required under Section 2 equal protection. So this is the conflict that had arisen. What actually happened in Texas is somewhat more subtle. The state of Texas gained 4.3 million people between 2000 and 2010. That's the state of Massachusetts, almost. Those 4.3 additional people qualified Texas for 4 additional congressional districts. Of the 4.3 million additional people, 2.8 million were Hispanic, 550,000 were black, 400,000 were white. Of those 4 additional districts, 3 were majority white and 1 was majority Hispanic. Okay. What is that evidence of? The courts concluded it was evidence, at least a piece of the evidence confirming that there had been intentional discrimination. But had it been a reduction? And these are questions we don't know the answers to. The courts must address now. More complicated still were when we dug into specific districts, what was allowed and what was not allowed. There are 3 kinds of minority districts. One are majority minority districts. That is where blacks or Hispanics are a majority of the voting age population. Simple enough. Second are called coalition districts, where blacks plus Hispanics are a majority of the population, and they vote together, and they vote against whites. And at the center of the Texas fight is a fight over a third kind of district called a crossover district, which is a district that's majority white. The whites are kind of split, like 60% vote Republican, and the blacks and the Hispanics are voting, say, 90% for the Democrats. But there are enough whites who cross over that allow minorities the ability to elect their preferred candidates. And the question before the court right now is that a minority district? And you can use your imagination to figure out what the implications of that would be politically in the United States if it is. The question then in Texas then is, how is the Voting Rights Act to be applied? There's nothing particularly new in the statistical techniques we've used, but things, the sophistication and the complications are such that we're really using everything we have at our power and our disposal, but nothing really new since Bernie Grofman wrote in 1986 what kinds of tools we ought to use. Now comes Florida. The state of Florida set forth a whole new set of criteria. And this is a constitutional amendment to the state law. First, no district or plan shall be drawn with the intent to discriminate against any party. Whoa. No district or plan shall be drawn with the intent to favor or disfavor any incumbent. No district or plan shall be drawn to reduce or interfere with the representation of minorities. Those are big principles. No districting law has ever been written with that broad a mandate. In addition, districts must be as compact as possible. They must be contiguous. They must minimize the crossing of county boundaries. They must minimize the crossing of city boundaries and voting tabulation districts or precincts. So this is a very sweeping law, and there were no precedents, no guidance as to how this law was to be employed. Florida also set up a preclearance process, a facial review. The state Supreme Court would review the plan 30 days after it was passed. So we had 30 days to do a complete analysis of the plan and say, this deserves closer attention. This deserves a trial. We won both of those complaints, at least the 2 that I was involved in, the state Senate and the congressional plan, and that proceeded to a trial. There was another part of the process, which was a public mapping process. The state of Florida set up, using publicly accessible GIS tools, a process in which people had input into the process. People drew maps, and those maps were submitted to the state Senate and considered as part of the legislative process for enacting districts. And our colleagues Mike McDonald and Mike Altman developed that software and helped implement it. And it was quite an impressive thing to see. What ultimately happened, though, in the case law was quite important, because what was discovered through an extensive, ugly, complicated discovery fight was that someone inside state government had somehow subverted that public mapping process. And the subversion of the public mapping process was the evidence that there was partisan intent in the Florida congressional districting plan. So Florida exemplifies both new tools being used, new GIS tools, new ways in which we can be involved. But it also sets forth these new principles for which we do not know really yet what the tools or analytical standards are going to be. So it's still a state in search of standards, and social scientists have a really rare opportunity to inform the further development of those standards. But I think where the Florida law really fell short was the problem of remedy. We'd won the lawsuit, but the trial court judge, who was the trial court judge in Bush v. Gore, had no guidance as to what could be done once a plan was found to have been infected with partisan intent. That's currently before the Florida Supreme Court, and we'll know what can happen next. But in all three of these cases, dozens of social scientists have been involved, providing counsel, providing evidence, providing testimony, trying to help the courts sort out what are the biggest issues facing the application of voting rights in the United States. Just to conclude, I'll offer a few parting thoughts. First, I think there are three really big issues that are outstanding in this domain. First, racial districts. What is a racial minority district? What kind of districts ought to be provided for? And what are the statistical criteria that we can point to that allow the courts to make a sensible decision distinguishing one district from another district? In particular, how can we distinguish a district that is a minority crossover district from just any plain old vanilla Democratic district? Second, party. What is party gerrymandering? What is a partisan biased plan? We still do not, after 200 years of the gerrymander, and it is the 3 years on the 200th anniversary of the gerrymander, we still do not have a definition that is legally acceptable about what partisan gerrymandering is. And finally, a question of intentionality. What does social scientists have to contribute to the ongoing debates about intentionality? Let me hint at an answer to that, which is the intentionality analysis have been dominated by traditional legislative history and historical analyses. We as a discipline have really pulled back from that. There aren't that, as the Department of Justice and various plaintiffs have asked me, who can they consult with, who can they hire as experts? The number of political scientists that I can point to who can help in that space is small and dwindling. However, there is a rising group of scholars who take a qualitative approach using textual analysis. And I think that will be the next, one of the next frontiers in the application of social sciences and voting rights. We will see continued expansion of GIS, sophistication, and methodology. We'll see improvements in simulations. John Roden and Joey Chen's efforts were just a foray, an initial foray. But I think the third area where we're really going to need to think hard as a field is in terms of remedies. If we have found quantitative evidence of, or qualitative evidence of intentional discrimination, what does that evidence tell the courts they ought to do to fix the problem? And there we've been remiss. We've been lagging. That's not to sound a pessimistic note. In fact, for those of you who know me, I'm quite the optimist in most of my life. I think that over the past 50 years of the Voting Rights Act, and it is 50 years this year, there's been an enormous improvement in the ability of minorities to vote and the ability of all people to vote in the United States and to have their votes heard. These are just the new frontiers, the new struggles, the places where we as social scientists have something real, exciting, and important to contribute. I'll leave with a few words of wisdom from Renee Hicks. So when I started really getting into this, I needed some more guidance from Renee about what's the best way to comport myself. I mean, who do I work for? Getting, pressure from this side or that side about what to say. And Renee said, you don't work for me. You don't even work for the people who pay you. You don't work for the party who's retained you. You work for the court. And it's your job to advise the court to the best of your ability of what you see and what you know. And the rest are irrelevant. And with that, any of you who are interested in moving in this direction, those are words to live by. And he said, if you follow my words, you will never get in trouble. And so far, I've stayed out of trouble.
Questions? So raise your hand if you have a question. We have one right here.
Given the stereotype that many of us would have of Florida politics, how did that law get passed?
Say that again?
Given the view, well, how did the Florida law get passed?
How the Florida law was passed through an initiative that was, it took about 8 years. And it was the League of Women Voters really pushed for it, developed it, built the coalition statewide to get support and ultimately got the initiative passed. The two other big reforms were California passed a commission and Arizona passed a commission. California was also through an initiative. If I were to point to models for state laws, I think the California law, most scholars now think, was the most successful of all the state reforms so far. In fact, in the middle of the Texas fight, a Republican state senator in Texas stood up and said, you know, maybe we should pass that California system. These litigation in Texas was unbelievably expensive, drain on the legislature's time, bad press for the legislature generally, and it was a fight that may have been politically costly to the Republicans because it further alienated them from the Hispanics, at least the state legislative Republicans in the state. Yeah. That Texas is already thinking about these other models. It's sort of an interesting statement that states that have been doing this through the traditional means are looking for an alternative.
Hi, I'm Nate Daugherty from the University of Missouri St. Louis. I was actually just going to ask you about the California Commission, but since you already brought it up, have you seen how this interplays with some of the voter ID struggles as well, or are they just completely separated issues?
The same principles are at work in the voter ID cases, showing effects, showing harms, showing what remedies are. Are there other ways that the laws could be written that are fairer, and showing intentionality. All the kinds of evidence that we bring to bear is of this kind of the same sort. The voter ID area was much newer, and in the voter ID case, the question that the Department of Justice, I was working for the Department of Justice, the question the Department of Justice had was, what kind of evidence are we going to try to collect? We could do kind of ecological regression analysis like you would in another suit, but what should we do? And the real choice was between doing a survey of people to ask them who had what kind of ID, or do a database matching exercise. And that's another social science advance that I think is going to be incredibly important in the next go-around, both in redistricting and other domains. We, Eitan Hirsch at Yale and I worked for the department on this case, and we merged the 13.5 million record voter file to the 25 million record DPS, Department of Public Safety list, to the Social Security list, to the Department of Defense list, to the Department of Veteran Affairs list, and so forth. Just to give you a sense of this, the voter file is 13 gigabytes. The DPS list is 25 gigabytes. We could not do this on any Harvard or Yale machine, right? So we set up an independent machine that had to be completely separate from the internet. The Department of Justice was sending and sometimes carrying the hard drive up from DC to us. It was quite an enterprise. The first time, we did this in 2012 for the Section 5 case, and we had to redo it after Section 5 was essentially gutted by the Shelby County case. The first day, the first go through, just passing through the data once, took us 22 hours. Right? It would have been an impossibility 10 years ago to do this on any kind of computer, but it took, it was kind of impressive on a desktop you can do this process. 2 years later, Moore's law is at work, surely the processing speed sped up. Took us 12 hours, and I was not happy with that because it was going to ruin my life if that was going to be the case. We called up Dell to talk about the BIOS, and I called up Stata to see if we could optimize Stata. After a few conversations, another $1,800 for the most advanced Stata with as much memory as possible. We reran it, and it took 25 minutes. Right, so on your desktop, this is just to give you a sense of what the revolution is that's coming with big data. On your desktop, you can take massive databases and merge them in a matter of a few minutes. And that's only going to continue to improve. I think we're going to start crossover between these problems. For example, I think that there are firms like Catalyst that have the entire voter list of the United States that they've assembled. Why not use that for redistricting? Right, that's the household level or individual level data can be used instead of precinct level data. That allows for a much finer grain picture. So I think we're going to start to see these two areas start to cross over in terms of the social science expertise and consulting that can be done.
Yeah, hi.
Hi.
Hey, Steve. I'm Richard Sobel, and for full disclosure, I work on voter ID, and I was just an amicus in the cert petition for the Wisconsin voter ID case on the cost of a free voter ID. And I've written a Scholar Strategy Network paper on this, and the Houston Institute has it. What are you finding about the impact of voter ID in the Texas case, to the extent you can talk about it? And where is that case currently? And do you have any projections on whether it's more likely to get cert than the Wisconsin case?
So we won, the Department of Justice won the Section 5 trial, and that was voided by the Supreme Court in September, August of last year. They won the Section 2 trial, the intentional discrimination. So there's a finding of intentional discrimination by a trial court. And the trial court finding was really extensive, and it's worth reading the opinion. They found intentional purpose, discriminatory purpose, discriminatory intent, and discriminatory effect. So this is bad news for Texas, because if that trial holds up at the that trial decision holds up at the appellate level, Texas, that could be the basis for Texas being brought back under Section 5. Right? So this is a big loss for Texas in that trial court. It was just a couple months before the election. The election already started. They already started sending out absentee ballots. That went right up to the Supreme Court. The Supreme Court stayed it, or allowed the stay. There was a stay. The Supreme Court allowed the stay to hold, so that it did not go into effect for 2014. But my understanding is, unless there's an appellate decision, this is going to go into effect in future years. So it's in an appellate court now. That court will make a decision, and then I think that will go up to the Supreme Court. The question is whether that, one thought was it was going to get merged with the Wisconsin and North Carolina cases. I don't think it's going to be. I think it's going to come up on its own, and I don't know which one's going to come up first.
So in terms of voter ID, did you find evidence of intentional discrimination in the application of the voter ID? The court found that. Is it based on your evidence?
The framing of this question is exactly kind of the Renee Hicks advice. Like, I just found that there was a disparate effect. The court made the finding of intentional discrimination. They drew the conclusion. I just provided them the data.
And how
I found I was one of many people working. Barry Burden from Wisconsin wrote an excellent report on the potential effects on turnout and so forth.
Okay. Can you explain to us how you found that effect of discrimination? And just a follow-up question. Do you think there's any possibility the Voting Rights Act will be amended so that Section 4 will be triggered again?
So we matched the databases. We found the number of people who were not found to have matched to any databases who were on the voter file. And then we had information on racial data that we got from a third party, and we examined whether or not there was a disparity. We also took the non-matched numbers, which are individuals who are not matched. We aggregated them up to precincts, and we correlated that using ecological regression with the precinct level composition, and we found exactly the same estimated disparity in minorities versus whites having ID. So that's the evidence. I don't know about as Werner von Braun said in the famous Tom Lehrer song, that's not my department, on Section 4. It's up to the Attorney General's office. I don't know what Congress is going to do on this. I was surprised by what happened the last time. I'll be surprised by the next time. Further questions? Josh?
So this is just very general, Steve. Josh Ober from Stanford. There's a lot of stories abound. There was a session in here right before 1 o'clock about the tendency in certain parts of the U.S. government now to be hostile to social science, to political science, especially particular congressmen. How do you see this going? I'm not asking for a conspiracy theory, but do you think that in a sense that social science, the kind of political science you're bringing to bear, can make a good argument to people in the government that actually political science is their friend, can actually solve problems that they want, or is the kind of work you're doing going to convince people in the U.S. Congress that you better shut down political science to the extent as possible, so therefore should we expect, to the extent that your work has impact, NSF will no longer be funding political science?
I think there might be rhetoric opposing social science, but I think that political consultants eat up what we do. In fact, many of them are us. Not us in our current instantiation, but students who've started political consulting firms all over the world. People are really intrigued by it. And the kind of tools that we are developing and contributing to the development of, such as GIS tools and better analytical tools and text analysis tools, are just exploding. Everybody's using them, and everybody's engaging with us directly. And if it's not us, it's our students. So there are young lawyers in the Voting Rights Division of the Department of Justice who were undergrads of Alan Gerber at Yale, and they learned data analysis from Alan. And I can go into the Department of Justice and have a really good, sensible conversation. And what's great about that is they know what hard questions to ask me. All right, so actually the pushback is great. That's like the back and forth that we ought to have. So I find actually this level of sophistication impressive and heartening, and the openness. Well, congressional level, it's more the staff. And again, it's the same story. The staff are in their 20s and their 30s. A lot of them are students of ours, or have, even if we didn't know them that well, they took our courses. The more we expose our students to social science, the better the future looks in terms of just these kinds of issues. Yeah.
Hi.
Hi.
I have somewhat of a selfish question.
Go for it.
I was wondering if you plan on continuing to collect the geocoded precinct level data.
So we're collecting the two things on this. One is I continue to collect the data. It's like summer project, so I've got a push coming up. So the way this proceeds is I collect the precinct level data, and then we overlay the maps to link the GIS data so the census data can be merged in. About 40 states subscribe to a project that Census started in 1972 called the Voting Tabulation District Project, which is great because that just like merges instantly. And then there are another 8 states where it's a lot of painful work. Kyle Drop at Dartmouth, been working on this, Joey and John, and so we've got this kind of network now forming of people. If you want to contribute to that in any way, you're more than welcome, and we would welcome your eyes, your mind, your time, your sweat, your sleep, everything else that goes into it. The other aspect is that there are firms, Democratic and Republican, that vend data to state legislatures, and I've been having conversations with 2 of these firms about the possibility of setting up contracts so that academics can actually do research through them, because they have data going back to the 80s or 70s in some cases of precinct-level election returns, not just for the elections that we've been looking at, but sometimes for city councils, some initiatives and so forth. So there's this other world of social science that's not in universities that is hugely important, and ones where I'm trying to open that up for the rest of us. So.
All right, unfortunately, we're out of time. Unfortunately, we're out of time. So please join me in saying thank you to Steve for a wonderful talk. I'm sure we could be here all day, but we have to make way.
Thank you.